Hi, I'm Guy DiMartino. I am a Northwest Indiana estate planning and probate lawyer. And today I'd like to explain the 3 ways that somebody can challenge a last will and testament or a trust. But before I get into the content, let me remind you that if you have any questions regarding a Northwest Indiana estate plan or probate matter, you can always reach out to me at indianaestatemeeting.com. Be more than happy to spend a few moments with you, answer your questions and concerns. So typically there are 3 categories or 3 ways that somebody can challenge a trust or a will. The first has to do with the technical requirements. For instance, in order for a will to be valid, the person has to be over the age of 18, the will has to be in writing, and if we're going to make the will self-prove, there has to be 2 witnesses and a self-proving affidavit. So if any of those things are missing in the will, then you can challenge the will based on a legal technicality in the formation of the document. Same thing with trust documents. Don't meet the legal formality of the document, then you can challenge the document itself. That's the first way. Second way has to do with capacity. And that means that the person who did the will, the person who is bequeathing their stuff, or the person who's the grantor in the trust, did not have the legal or testamentary capacity to enter the contract or to prepare and sign the will. This means that they did not have the mental faculties to understand what they were doing, to understand their estate, to understand their assets, to understand the people involved, to understand how they wanted to separate or provide for the people involved, what to bequeath to certain people. So testamentary capacity would be the second way in which somebody can go ahead and challenge a last will and testament or a trust. And finally, undue influence, and that would be the third category. And that means that the person who is taking under the trust document or is getting stuff under the last will and testament was in a fiduciary or a special relationship with the decedent or the grantor in the trust, and they put or coerce them by putting power. And some of the things or elements that we would look at in trying to challenge for undue influence is, number 1, the nature of the relationship between the decedent or the grantor and the beneficiary. Second thing is how involved was the person who is taking under the document, who's going to get stuff under the document, how involved was that person in the creation of the document? Did the beneficiary go out and hire and find the lawyer? Did the beneficiary pay for the lawyer? Did the beneficiary take the grantor or the decedent to the lawyer's office? Were they involved in the discussions with the lawyer? Did they know what they would be getting? Did they have a copy of the will or trust document before the grantor or decedent passed away? See, all those things would tend to be used against the beneficiary, that they were too involved in the process, and maybe they went ahead and coerced the person into putting the certain terms in the document in which they're getting stuff. So there you have it. There's 3 general categories of ways to contest a will or a trust: the formalities, legal capacity or testamentary capacity, and undue influence. If you have any questions regarding a Northwest Indiana probate or estate matter, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.